Justice Alito?
If we look at all of the limitations and the restrictions and the variable limits, how can the provision satisfy any sort of heightened scrutiny? And does that cause reason for legitimate skepticism about whether this is about circumvention at all, as opposed to other things like favoring incumbents, favoring major parties, etc.?
So are you talking about, for example, the 2014 new accounts?
I'm talking about all of the restrictions and limitations.
So I think each one of these restrictions and limitations has a constitutional, either a constitutional reason or a constitutionally motivated reason. So, for example, the 2014 accounts, something I'm very familiar with. The reason why the legal account was treated in this new law was because prior to that, there was, and remains on the books today, a regulation, 11 CFR 100.9 and 100.15, that entirely exempt recounts from the campaign finance laws. Entirely. If you go back to the Bush-Gore recount, none of that money was paid out of the hard money accounts. What happened is that after the McCain-Feingold law, after this court's decision in McConnell, there became a genuine question whether, because of the ban on national parties and candidates raising spending, directing or controlling, apologize if I missed a word there, soft money, whether those regulations were still in effect. So Congress in 2014 clarified, against a backdrop in which, by the way, many Republican elected officials were taking the position it is still unregulated, unlimited.
All right, but well, I don't want to take the time to go through all of these one by one. Just one more. The difference in the limit for, which was talked about, the limit in California and the limit in Wyoming.
Yeah.
How is that, how can that be seen as based on preventing circumvention?
So look, and you see this in states as well, in various state campaign finance laws. Legislatures have one of two choices, or a combination. They can either say, we don't care whether you're running for insurance commissioner, county council, or governor. The contribution limit is $1,000, or $5,000, whatever it is. It's just a flat limit. In some states, the limits for governor are higher than the limits for town council, or higher for governor than they are for legislature. And those have never been viewed as constitutionally suspect. The theory is that for some offices, it simply costs a lot more money to run a comparative campaign, and therefore they're going to set different contribution limits from donors because they are reflecting the difference in the cost in running campaigns.
Well, I don't think that helps you to say that, unless I'm missing the point. Is there a greater, is the degree of risk of corruption different in those two places?
They are, because the fact is that it is not that the good people of Wyoming are any more likely to be corrupted than folks in California, but the value of a $100,000 bill pay for a television ad in Wyoming might be a week's worth of television. In California, the value of a week's worth of bill pay for a television ad wouldn't buy you a single spot in Sacramento.
Okay, I understand. Thank you.